Can I have a thumbs up if we have the recording button? Yes, cool. Okay. Hi to everyone at home. This is the week 6 Zoom workshop for IP law. And this week kind of, okay, there's my meeting reminder. And this week is a fairly important week because we kind of get to the end, the very end of our discussions of the various different IP rights and, you know, what those IP rights can do for us in terms of remedies that may be sought. So we need to clear up any lingering uncertainties about infringement and remedies. So we'll be briefly recapping some of the infringement discussions that we had on the way through, just to kind of refresh our memories. And we'll be looking at, you know, obviously what remedies can be sought for the various different kinds of infringement that may or may not have gone on. Now, we have Gemma here, we have Jeff, Jack, Marshall. So we have a few people absent. It's only 6:02, but I think we'll, hi Kate. I think we'll kick off anyway. And just hopefully the other people that are slated for grading during the workshop will pop in at some point. Okay, so hope everybody had a nice Easter break. Hope everybody's managing to chip away at your various different assignments. If there are any issues in relation to group work, please email me. I've had a couple of groups email me now. If you're having any issues or need clarification, I'm only too happy to provide that. Just send me an email and we can sort things out. Now I'm going to share my messy screen again so that we can have a little look at my document here. This is, I think I said this last week, but I lied. I think this is the final time that we get to see Nigel and Roy's problem. And as I said, we're looking at things from a remedies point of view now. Before I actually launch forth into all of this, can I just have a little indication in the chat box for whether or not people have had a chance to, you know, have a little look at the materials for this week or not. Just so that I can kind of get an idea for how people are traveling with all of that. Now let me stop my sharing. Doesn't seem to be letting me see what's happening in the chat box if I've got my sharing on. Chat. There we go. Oh, good eye. Oh, that's okay, Gemma. We all have those weeks. Yes, midterm break is often prime pickings for doing assignments. I fully appreciate all of that. Yes. Now, I had to, even with somebody like me who has had a fair bit of experience with all of this stuff, don't whip yourself if your eyes start to glaze over with this kind of stuff, because, you know, there is a lot of dense text in that chapter. There's a lot of dense text in the whole thing, but this text is probably about the best that I know of on the market that is doable at a level that suits this unit, just as a bit of a cook's tour. All of the other IP texts are really, you know, they're like your contract law texts, so they're massive, and they're not the kind of things I think that are, you know, they're all about $150, $200. and they're not worth it. So even though this text does tend to have its faults, I don't mind it on the whole, but I will admit this chapter was pretty dry. What I wanted to kind of do with tonight's shoot was shoot the breeze about the different remedies that you can get, maybe draw a few comparisons and contrasts so that the differences between the different remedies are a little bit more clear than perhaps they come out at you in the text, or maybe, you know, they've come out at you in the text, but that was the moment that you, like me, your brain chose to switch off and not digest anymore. I will start sharing again, and I'll go through. Now, can you see what I've got here? This is my little IP infringement and remedies ready reckoner. Have you downloaded this at all? I've got it on Moodle for you. It's already on Moodle, and in fact I have made a few little tweaks to it today. Dang it, so if you've printed it, it's probably about 3 pages that you've, oh no, yeah, if you've double-sided it, then that'll be 3 pages you've wasted, unfortunately. But I have kind of expanded it a little bit for you. And what I do in this little infringement and remedies ready reckoner is I just run through the different IP rights, so patent infringement, and then I step you through like my thinking on the way that the legislation all kind of joins together, and then I pick out of the legislation the relevant bits that you need to stitch together when you're thinking about infringement and remedies and what you might be able to get. And then because this is the week on remedies, I've just kind of summarised everything in the remedies column at the far right-hand side. So I hope that this helps to make things a little bit clearer. And if you did nod off in the text, just have a little look at this document, because I think it should hopefully make it clear to you how the legislative framework hangs together for each of the different IP rights. And then at the end of, so I've got that copyright should probably start on the next page. So then I've got copyright, and then I've got trademark infringement. I'll start that on another page. And then I've got breach of confidence and passing off. So, and then down the bottom, if you wanted to have a quick ready reckoner for all of the different sections on injunctions, I've gathered them all together for you at the end. Same thing for damages. And I've just made a few comments on the other different kinds of issues that you might encounter in relation to infringement and remedies. So if you did find the text a bit difficult, see if this document makes things any clearer for you. So that is just a little advertisement, if you will, for that document. Now, in terms of our problem for this week, we are all very, very well aware of the facts that are behind the problem. And the preparatory questions: if Nigel and Roy were to sue Fred for passing off or misleading or deceptive conduct, what remedies would they seek, and would they succeed? So Fred, as we know, is the little manager that was with Nigel and Roy for some time. There we go. He was one of the youths that they employed on a handshake deal rather than using a contract. And he sets up across the business, across the road, as Hungry Eat It Max. Okay. he obviously had knowledge of what was in that business manual, all of the ingredients for the 11 secret herbs and spices and the way that they went about making the burgers. And he obviously used the burger flipper, so he was able to make that himself to use in his business. If he's going to that level of detail, you know, obviously he's not just using the ingredients, but he wants everything to be pretty much exactly as it is at Nigel and Roy's, so he uses the burger flipper as well. His efforts have yielded him some success because he pitches his burgers slightly cheaper, so he diverts some of the trade across the road to himself. So we had a little look at this previously when we were looking at passing off the misleading or deceptive conduct. Let's just step through the elements of passing off again, just to kind of brush up on, do a little bit of revision on the action for passing off. So firstly, elements, first one, what do we need to...
Reputation.
Yes. Okay, so how can you recall how we said the other week when we were talking about passing off, how we go about proving reputation? There's a few different things the court will look at in proving reputation. Essentially, that's business goodwill, isn't it, that you've generated by way of trading. So what is the kinds of evidence that the court's going to be looking at when you're trying to establish sufficient reputation? How
well they've done business-wise, how much sales they normally do, advertising.
Yes, sales is certainly one. So you're looking at things like turnover statistics. Yeah. You are also absolutely, you are looking at advertising budget. You'll also look at things like if you can perhaps show other things like length of time, market share, etc., etc. These are the things that the court is going to want to see. We do know that it's a fairly geographically constrained market, don't we, because it's Smallville. So in terms of passing off, there would be a problem if Fred was located a fair way away, if Nigel and Roy's reputation was only, for example, within 5 or 10 kilometres of Smallville. So there's your problem. That's a big problem for passing off. Here we don't really seem to have that issue, do we? Because Fred's like right across the road. So do we think reputation, sufficient reputation?
Yeah, last week when we did it, we determined that there was sufficient reputation in the geographic bounds.
Yeah, I think so. Boy. We know that business was booming, don't we? There we go. Business boomed. So certainly they opened their first store. Then pretty much as soon as they did, crowds flooded in. Business boomed. And then we have the employment of Fred. So a fair amount of time has gone by. Fred has had enough time to work at the shop as this part-time manager, get familiar with the recipe, get familiar with business operations. He's also had enough time to use the burger flipper and study it sufficiently that he's been able to replicate it. We've also then had him obviously thinking, I should probably open up my own shop here. He's gone and he's looked for a shop to lease. He's found one right across the road. Think of all the time that this takes. How long does it take to negotiate a lease? Normally that doesn't happen overnight. Then he's had time to fit out a shop. So he's had to engage the contractors, get all of the kitchen equipment put in, unless it was already there. He's had time to get all of the supply arrangements, so supply of meat and other products that he's going to need to use. He's had to look for staff to man the shop. So all of this takes time, doesn't it? And I would say that Nigel and Roy would have to have been trading for at least 6 months by the time Fred opens up shop across the road and starts to impact on their business. So I think given that there's about anywhere from 6+ months worth of reputation in trading, plus we know that business boomed,
AJ, with the fact that it's a small town as well, I guess encourage that as well, because it leads into the next one, which is the misrepresentation, because it's easier for them to get mixed up because it is such a small town.
Yes, absolutely. Absolutely. And I think that that definitely works in their favour, like you said. Let's move on to that right now. Misrepresentation, as Kate said, that leads to deception. So we've got, you know, Fred could have opened with a sign like this, or he could have opened with a sign like the little people that I saw at Chugan just up the street here. Like this. We don't know exactly how he has decided to open up his business, but we do know that it's pretty rich to do that kind of thing right across the road, don't we, in a small town. So all of the things that we were talking about, yeah, town, you would have familiar with the new burger place, Nigel and Roy's. Confusion may be more likely given that people wouldn't think a burger place with almost the same name could open across the street without some kind of affiliation with Nigel and Roy. Yep. We do know also that the sign was in red and yellow, like Nigel and Roy's. Does that have any bearing on anything?
Well, the colours then, obviously, they make it look like there's more of a connection between the two.
Yeah, I think they do. I also think there is something to it here in that, I guess when you're talking about reputation, one thing we didn't make specific at the beginning of our discussion is that he has used the name Hungry Eat at Max. But you might also point to other things like similarity in the food and get up of the sign, etc. And here you would be making an argument for passing off Nigel and Roy's trade dress. Remember we talked about trade dress and the look and feel of a business? And we were saying that trade dress is something a little bit more broad than just a trademark like Hungry Max. It's bigger than just that. So if you were going to be making a broader trade dress argument, I think you would probably also talk about colours and things like using the same ingredients in the same burger flipper to replicate exactly the experience of Nigel and Roy's restaurant. Yes? What about the third? I think we could probably the third one, the third element.
Damage to goodwill.
Yes. And do we know whether or not there's been damage?
It's always financial. Sorry, Gemma, you go.
Immediately impacted on Nigel and Roy's profits as his burgers were cheaper. Okay. So, yes, Nigel and Roy have lost profits. Okay, so it seems like we can hop over everything like we got through in the other tutorial. Sorry, there's someone that wants to say something in the chat box there, and I can't find the chat box. Where is it? There it is. Can use the defence somewhat that Roy's surname is McDowell. Oh, yeah. Good point. I hadn't, in fact, that was a throwaway reference to the Eddie Murphy movie Coming to America. I don't know if anyone's seen that. I'm showing my age there. That's a 1980s movie. Remedies. Now, please tell me, what could they get?
Probably an injunction for passing off.
Yes. Injunction would be the biggie, wouldn't it? To restrain Fred from continuing to trade with the same trade dress. Yep. What else?
They could go for damages or accounts for profits.
I was glad you said that. Because I wanted to tease out the differences between the two. Now, it's super hard for a court to actually work out this stuff in practice, but there are some fairly interesting differences to what you might get in terms of damages and what you might get in terms of account of profits. So can we go through what are damages meant to do?
To compensate for loss, for the plaintiff's loss, just to bring it back to us where they would be should the breach not have occurred.
Yeah. And this is generally speaking called the tortious measure of damages or the compensatory measure of damages. That's exactly right. So forensically, the court will need to work out what was lost. There's a couple of different ways that a court can work out what was lost. Apart from, Nigel and Roy could say possibly, oh, well, in the first week he started trading, our profits went down by, $100. The next week they went down by $500. The next week they went down by, $1,500. That's certainly one way to calculate damages. There are a number of other ways, and we'll talk about that when we're talking about the statutory IP rights. Account of profits, what's that all about?
So it's designed to take back from the defendant the profits made through the unauthorised use of the intellectual property.
Now, can you get both?
I'd say not. Thinking back to equity, you sort of only get one bite at the cherry.
Yes. You have to elect. You can ask for both and then worry about it, and you usually do worry about it later. So normally there'll be a hearing on the issue of whether or not you succeed in the action, and then there's often a separate hearing on the remedies that you might get in terms of damages and calculation of damages. So what you need to be thinking about is how much have we likely lost as a business from this conduct. So like I said, in that silly hypothetical I just made up, 100 in the first week, 200 or 500 in the second week, 1,500 in the third week. So you're looking at a total loss of 2,100 there. But if in the same amount of time, Fred made, I don't know, maybe because his burgers were cheaper, he got double the business of Nigel and Roy. So potentially say that Fred made $1,500 in his first week, $2,000 in his second week, $2,500 in his third week, then you can start to see, well, it may be more beneficial to elect for an account of profits. So you've got to always keep that in mind when you are advising your client. Ask for both, sure, and leave it till the kind of the 11th hour, if you will, before you really decide which way you want to go. But it can be, depending on the nature of the circumstances, quite lucrative to ask for an account of profits instead. A lot of this discussion is a little bit pie in the sky because mostly with a passing off action, you're going to be, as Jack said, you're going to be looking at mainly an injunction. Okay. There's very few of these things that tend to get litigated on the issue of damages. Okay, good. Let's go on to misleading or deceptive conduct. You have to have a person must not in what? Trade or commerce engage in conduct that is or is likely to mislead or deceive. Okay, now, person, we did have a discussion about this before. A person, is that a corporate person or a natural person? And when can you sue on the ACL, and under what legislation will it be? Will it be the federal legislation or your state legislation?
I think, remembering back, it was state legislation you can sue the individuals.
Yes.
And federal you can only sue corporations.
Yes, exactly. And there's only very few limited circumstances where you can actually use that federal legislation against natural persons, and they have to fit into that very slim few heads of constitutional power that the federal parliament has to legislate on this stuff. So they've got to either be using federally regulated utilities like postal service or telecommunications, or they've got to be engaging in interstate or overseas trade or things like that. So generally speaking, if you are actually trying to use the ACL against a natural person, you're going to have to be looking at the state legislation. Okay, so person must not. So yes, Fred is a person. So tick there. In trade or commerce. Is Fred engaging in trade or commerce? Trading as a burger shop. So shop. Tick there. Misleading or deceptive, well, we've just said, yes, it's most likely to mislead or deceive. We needed to, obviously, for misleading or deceptive conduct, we needed to, if you were going to flesh this out, like in an exam answer or something like that, you're going to have to think about who are the class of consumer that you're looking at for this kind of thing. Is it an expensive or a quick purchase? How likely is that to impact on the ability to mislead in these circumstances? You'd be bringing in cases like that Parkdale and Puxu case, the Nike case, the Campermaster Ciudad case, those kinds of cases, and you'd be discussing all of that there. What are your remedies under the ACL?
An injunction?
Yes, you can get injunctions. And?
Damages?
Yes, that's under section 232, by the way. Damages. Do we know the section? 10 gold stars, if anyone can tell me this section.
236.
Woohoo! What else?
Is it compensatory orders or something?
I was hoping someone would say that. Yes, yes, these are lovely little things, aren't they? Did you have a little look at these, the compensatory orders, when you were doing contract B? I'm going to take you to them just very quickly because I think they're hilarious. Okay, so let's go down to the schedule. And we have a little look at, can anybody tell me what the section is for the compensatory orders?
237.
Lovely. Yes, 237, and it has a little partner there as well. Sorry if I'm making you seasick by scrolling down like this. I know it's annoying. Okay. Here. By an injured person. What? Oh, lost it. There we go. Injured person or the regulator. Okay, so we're sweet here. We can, so far as Nigel and Roy are concerned, we can apply under 237. Make such order or orders that the court thinks appropriate, and for the kinds of orders have a look at 243. So then you scroll down to 243, have a look at all of this stuff. A lot of this is where you've made a contract with somebody and you want to get out of it or have something done in order to fix it up. But there's all sorts of, you know, things that the court can do. And these are just here. What I want to say here is this is all just indicative. Okay, so this mostly relates to things that you can do in terms of contracts. This relates to transference of land, but they are just indications of the kinds of orders that can be made. So if there was some kind of adjustment, for example, that needed to be made between Nigel and Roy and Fred that didn't neatly fit into the definition of damages under 236, then Nigel and Roy could claim for whatever orders that they wanted under 237. Okay, so can you get exemplary damages here? Can you get additional damages under the ACL for particularly naughty conduct?
No.
No. Good. I'm seeing people shaking heads. No, in fact, you cannot. More's the pity for Nigel and Roy. Alrighty, let's flip back to our document here. Where is it? We'll get that back up. Oh, I must have swished it out of the way here. There it is. Okay, so there's no additional damages. If Mary sued Nigel and Roy for copyright infringement, what remedy would she seek? Or what else could she practically do? Would she succeed? What do we need? Where do we start with copyright infringement? Let's step through what work is at issue here.
Her design?
Yes. Mary's artwork. A winking man with the thumbs up. And what else? Remember? 11 secret herbs and spices, and I made some kind of reference to KFC. Cool for chewing or something like that. Yes. So remember when we were talking about copyright, did we think that the artwork was going to be protected as an original artistic work?
Yeah, I think we had the artwork was, but the slogan wasn't.
Yes, that's right. And the reason why the artwork, there was no suggestion of it being, I mean, it's a very low threshold, remember? This is a good kind of refresher for all of the discussions we've had so far to tie everything up for us. Well, that's the intent anyway. So in order to be protected as an original artistic work, the threshold for originality is quite low, isn't it? It's just basically so long as you haven't copied something else of someone else's. Artistic works normally don't pose too much of a problem, but in terms of originality for literary works, okay, what was the case? Can anyone remember? The case that talked about the newspaper headlines and whether or not they were protected. And one of them was the resort that offers precious little. And the other one was somewhere in the Whit Sundays. That was the Sullivan and F&H case. Depending on whether you thought 11 secret herbs and spices make our burgers cool for chewing was going to be considered along with Sullivan and the F&H case as being too pedestrian and commonplace, you might come down on the side of no protection. Or if you thought, you know, cool for chewing, the misspelling of cool maybe shows that creative spark that they were talking about in the ICE TV case. Depending on what way you came down on that deliberation, it might be protected or it might not. So what section are we talking about in terms of copyright rights, and do we think infringement might have occurred?
Section 14 with like, because they took the whole thing for the artwork.
Yep. Whole artwork. Oops. So, yep, in terms of section 14, that's satisfied. What's the actual right for original works? What's the section we look at here? I'll take you to the legislation if it helps. Let's have a wee looky here. Copyright Act.
Is it number section 31?
Yes, thank you. So, In the case of a literary, dramatic or musical work to reproduce in material form, well, they've done that, haven't they? Publish it. Well, I guess if they put it on napkins and things like that, potentially. Communicate to the public. Well, perhaps if they've put the slogan on the illuminated sign on the menu, possibly. In terms of artistic work, reproducing material form, again, if it's on the shop front, that'll be an infringement. If it's on the menu, illuminated menu, that'll be an infringement. If it's on the napkins, all of that kind of thing. It's potentially a doing of an exclusive right that is contained within copyright under Section 31. Okay. So let me just pop that down. Section 31, if copyright subsisted in the literary work, it'd be probable infringement of Section 31(1)(a), and then for the artistic work, it was Section 31(1). I think it was just B, wasn't it? Yes, B. Okay. In terms of the tests, we know that there has been a substantial reproduction of both. As Jack said, it can be the whole of the work as it was here, or as long as it's been substantially reproduced, it's sufficient to constitute infringement. Remedies, please. Remedies.
Injunction.
Yes. Oh. Injunction. Although, is that going to be her main objective? What will she really want? What would your client really want? If Mary came to you, what would be on
Probably
her?
damages.
Yes. Really, it's all about the dollars, isn't it? Possibly.
And in the alternative, if she didn't want to litigate, she could pretty much, say, sell or assign the IP right to them for a decent amount of money.
Aha! I like the way you think. I'm gonna put some quotes around that. Practically, we did touch base on this before. What kind of havoc could she wreak for Nigel and Roy's trademark application? Because this is the other thing she'd be saying to them. We know that Nigel and Roy have applied for a trademark for Hungry Max and probably the slogan. And the artwork we know they want. So what else could she do? Think laterally.
Is it putting in like an opposition or something to their application?
Yes, it is. Now, remember we said there was a provision in the legislation that looked like it was relevant, but in actual fact, it's not. So, here, removal, I'm looking at here, opposition. There we go. Grounds. Remember we said that there looked like one provision that might be relevant in this situation, but that's not actually the provision that you would use, because the owner of a trademark that would use Section 58 to object to somebody else registering the trademark, the first owner is the person that has actually used it out in commerce first, and Mary hasn't done that. Okay, so remember, we said that if Mary was going to object, she would look for, it was 44. 40, contrary to law, 42. So, why could Mary use that provision? Remember how this all stitched together?
Because it was violating her copyright right.
That's it. Their use, unauthorised use of her drawing and her slogan would be copyright infringement. Yes, precisely. So she can muck up their whole trademark application for them. And that is a very strategic problem that is often posed in real life, and I've come across that a number of times. So you
Sorry,
don't...
AJ, if they already had the trademark in, so then they're essentially, they've trademarked it, can she come in later with that clause?
She can, very good question. Very good question. We're switched on tonight. Let me go back here. So, you know, a trademark gets applied for, it gets advertised as accepted, then after acceptance, then you have the opposition period. So it's not on the register yet. You have the pre-registration opposition period. And then if you get over that hurdle, then there's registration, and then you have the possibility of revocation. And I'm so glad that you brought this up, because this is where what I like to call the IP game of chess really starts, because it's all a bit of a series of bluffs, moves and counter moves that you've kind of almost got to strategize about like it was a game of chess. And certainly the problem wouldn't just go away if Nigel and Roy managed to get onto the register and she missed out opposing it. She can actually try and knock that mark off the register by mounting an action for revocation. And that can be done for both trademarks and patents, and is a really common strategy. And that is why most people, actually most IP owners, are very reluctant, apart from all the cost and all of that, why a lot of trademark owners and patent owners are very reluctant to actually go to court and let the proceedings play out in their entirety. Because usually the first thing, if you sue someone for infringement, the first thing that they will do is counterclaim to have your rights revoked. And they will try and find any little loophole that they can to unstitch that IP right. Obviously, because if they can get the trademark revoked or the patent revoked, they can't infringe a patent or a trademark that's not registered. Yes?
Is that where the threats come into it?
Yeah.
The next part? Okay.
Yes. It's fun, isn't it? It really is all a bit of a game of bluff and bluster.
That's what I didn't get when I was reading this. It was like the federal court plays kindergarten teacher and everyone else points fingers.
Yes. That's exactly it. That's exactly it. And there's so much cost and expense. I don't know if you saw that little, I think I put up a little speech by Justice Yates that he gave, I think, a couple of years ago about remedies. And he makes the point a couple of times in his speech. There's not that many cases that play out right to the end and you have to assess damages and, you know, they have to either elect for damages or on account of profits or, you know, all of this stuff, because they usually settle. They'll usually start, there'll be all this bluff and bluster, and then the proceedings will go along, and then invariably you'll get a settlement happening. That's the usual way that this stuff goes in practice. And because for a trademark owner, it's much better to settle than have their IP right knocked off the register, and usually cheaper. And for the other party, they can often come to quite a lucrative arrangement with the IP right owner, and often that will be taking a license from them. So it's all about the negotiations, really. So that's why I wanted you to kind of start thinking laterally about the, the things that are in someone's armoury, apart from just asking for damages or injunctions and that kind of thing. Trademark infringement, can we just briefly go through what we think, what the sections are here, relevant sections? (120) is the section for trademark infringement. You can only sue once your mark's actually on the register, aren't you? I think this is where Kate was going with this. So here, Nigel and Roy only have a trademark application. Do they actually have it granted? No, they don't have it granted yet. Okay. Let's see. In the ground, externally. Pretty man. Yes, here. It's been accepted and published. And that's why we were talking about Mary and filing opposition proceedings. So they only have an application. So hang on a second. I've had a brain spasm here. Section, I'm not talking about Nigel and Roy at all. We're not talking about their trademark application. We are talking about McDonald's suing them. Sorry about that. Brain meltdown there. So Nigel and Roy would seek the remedy of sorry about that, people. Unjustified threats. And they couldn't get around that. What's the best way? So if Nigel and Roy actually, said to Macca's or Hungry Jack's, hang on a minute, this is an unjustified threat. What's the thing that will cure proceedings for relief from an unjustified threat of infringement proceedings? What could Macca's or Hungry Jack's do if Nigel and Roy said to them, hang on a minute, you're just making unjustified threats?
Don't they actually have to follow through with the threat within a reasonable time?
Yes. So what would they do?
I can't remember exactly what it was I read, but they have to actually start proceedings, and there wasn't a time frame in there. It just said within reasonable time. So you can't just threaten something, then all of a sudden 10 years later follow up on that threat.
That's exactly right. That is exactly right. And this is why I say it's like a game of chess here. You really need to think about how deep your opponent's pockets are and what they are likely to do depending on what relief you're seeking. So if Macca's or Hungry Jack's sued Nigel and Roy, you can pretty much bet your bottom dollar that they are going to have enough money to just start infringement proceedings if Nigel and Roy start jumping up and down about unjustified threats. However, if, for example, it was a local trader that was making this noise, you might well chance your arm and in a letter, responding to their bluff and bluster. I mean, we know that here Hungry Jack's and Macca's have sent bluff and bluster, letters here. Your business has no prospects of succeeding. We have a worldwide history of brand protection. Hungry Jack's also said we're flagrantly attempting to write off Hungry Jack's reputation. If you wrote back and said, I think that you're making an unjustified threat and we will seek relief from the court if you continue, like I said, those big guys would probably just sue you. A local trader, maybe not.
Sorry, AJ, if that was all that was written in the letters, that's not considered a threat.
We have, you don't actually have to, as long as, let's see, your business is flagrantly attempting to write off Hungry Jack's.
Yeah, but I thought there had to be a threat of taking them to court essentially, or something along the words. There was like a whole bunch of different words that they had to use.
No, they don't have to actually say that they will take them to court. It's even been held to be an unjustified threat, just saying that you reserve your rights in this matter. I think these would be on the safe side, on the safer side. Usually what you can do is you can bring your IP rights to the other party's attention. Here, I think probably the McDonald's letter would be okay because that's pretty much all you've done. Here...
Wouldn't it be this, because there's one in here, the Intel Mail Explorer one, and that's where they said it was just a catalyst to start negotiations.
They failed on that, though. They failed on that.
Yeah, because then later on it was like the other wording that was in there. So they reserved the right, as you said before, and then will be commenced forthwith. But there had to be something in there to say things are going to start. Well, that's what I read anyway. Yeah,
I think I've only done a few of these, but I think my rule of thumb, or the old firm I used to work for, their rule of thumb was you can point out that you own the IP right that you're fighting about, and you can point out that you know that they are using the whatever it is that they're using, and you can point out the similarities, but that's about the closest you can come to the line. And you're normally very careful. I thought the one that they gave the example here in the text was fairly, there was one, just trying to think, and I actually thought, maybe that's falling on the safe side of things, but it wasn't.
It just seems a little grey. I don't know if they could jump straight in and say that's a threat.
Yeah, I think probably the Macca's letter would be okay. I think the Hungry Jack's letter is a little closer to the line, and it would probably depend on, you know, the rest of what was said as to whether or not the test is that the reasonable person would conclude that action would be taken. So I guess it would probably depend on how the rest of the letter read. I agree the Macca's letter probably would be fairly safe, but the Hungry Jack's letter probably, if there was anything else in the letter that suggested they were going to move on this, yeah. But again, it's probably, I'm just thinking also, it would be interesting to know whether you could stitch together any other conduct. Because often what will happen with this stuff is, it's interesting, they will follow up with a phone call. And I was just thinking it would be interesting if you could stitch that up. You know, if you had the stern letter from them and then you had the typical phone call from their trademark attorneys, which is usually, you know, the big guys in Sydney, whether you could stitch that all together and make an argument of unjustified threats. It's interesting, isn't it? But anyway, sorry, we're running out of time here. Unjustified threats. Section 129, the response from Hungry Jack's or Macca's, either way, would just be to file infringement proceedings. But as I said, you'd probably have better luck with a action for relief from unjustified threats if it was a little person who didn't want to go to court. Patent infringement. Let's wrap this up. Section
Is it section 13?
Yes, 13 is the exclusive, right? And is Fred exploiting?
Yeah, he's using it in his own commercial and as part of his own commerce.
Would he succeed? Would Roy succeed against Fred?
Reading the scenario, it doesn't look like he's been granted the patent. It says he's simply just he's applied for it.
Yes.
And it's in the specification page, so probably not.
Yes, that's right. This is where I think my brain was going when I was talking about the trademark section before. Yes, Roy's only applied for the patent, so he wouldn't succeed here. So if Roy did threaten, we would be back in the territory of
Is it infringement?
Yeah, if infringement proceedings were threatened, this would be an unjustified threat. And under the patent legislation, that's section 128. Okay? The problem here, again, and this is where I want you thinking about the game of chess here, if Roy threatened infringement proceedings against Fred, if the patent were granted, what would Fred do immediately?
Counterclaim for revocation.
Yes. And we know that this would stand a good chance of success because there is a big weakness in Roy's invention, isn't there? Can we remember what that weakness is related to?
It wasn't just because it was a generic flipper?
He replicated Roy's burger flipper easily. Easily. So that goes to the requirement of, so patents have to be, inventions have to be novel, involve an inventive step, non-use, have to be a manner of manufacture. What step does this relate to? Inventive step. Okay, so if the invention would be obvious to a person skilled in the art, then it's not a patentable invention. Okay, so obviously if Fred's replicated this easily, there's a big weakness. If somehow by some miracle Roy got this through the patents office and it got registered, it would be very vulnerable to revocation. And this is the typical example of where Roy would be negotiating very hard for a settlement rather than for this to go to court. So that is where that game of chess would play out. Okay. You would definitely be trying to knock that out for lack of inventive step. Okay, practicalities. What would you do with the parties here? We'll just wrap this up. What would you do with Fred? He's passing off, diverting trade.
You'd sue and go for either damages, either an injunction in your first instance or damages, and you'd ask, as you said, ask for damages or what's the word? Lost it.
Account of profits?
Yeah, account of profits.
Yeah, on a strictly legal reading of this, but what I want you to do is start thinking laterally and practically. So given
Wouldn't you want that business to be closed down? Because it's, at the end of the day, if it's going to be causing that much of an issue in a short period of time, you want it gone.
Yes. So it just depends on, you'd have to do the numbers as to how much it's going to cost you to litigate and end the business that way, as opposed to potentially negotiating a settlement with Fred and agreeing that he relocate his business elsewhere and not use your trade dress. So I want you to always think, before you recommend litigation to any client, you need to be thinking about settlement. Okay, it's going to be costing your client minimum $150,000 to litigate, and you are not by any stretch of the imagination assured of a successful conclusion to your trial. Okay.
It might be a little bit outside of IP, but realistically, did Nigel and Roy need to let it get to this stage? If they, as you said, it takes a long time to open up a business and small town, etc., they would have known exactly what was going on pretty much probably from day one when Fred said, see ya, I'm opening up my own business. Could they realistically thinking, could they have filed an injunction earlier?
Well, it depends. It would depend on whether or not he was actually engaging in the passing off. So if they just found out at planning stage, well, he's not actually engaging in passing off at that point. But what I certainly would be doing is saying to Nigel and Roy, look, there's two options here. You can either settle and get him to agree to relocate elsewhere. You can pay his relocation costs. It's still going to be probably cheaper than actually litigating this thing. And you can get confidentiality clauses put in there so there's no adverse media statements or anything like that made, or he doesn't go blabbing around town what's happened. Or the other classic way to settle is to grant Fred a license and skim his profits that way.
So, AJ, going back onto Jack's thing, could they go into the Anton Pillar audits? Because if they could prove that him opening up his business would cause, issues, could they go down that path?
Anton Pillars are almost never ordered.
Oh.
Almost never, because there's such an extreme incursion. And apologies for anyone that has to nip off to property. We'll finish this up on recording.
We're the last two.
Oh, okay. I can't see anybody else. The Anton Pillars are normally only, granted where you can show clear and convincing proof that the other party will destroy evidence, usually, because it's such an incursion on your constitutional rights. Because what you're doing is basically allowing someone it's a court-sanctioned trespass and seizure. So usually that kind of thing, you would need really clear evidence of naughtiness going on and a likelihood that he was going to, destroy all the evidence. I think the cheapest and easiest way out here, honestly, would be settlement. I know that clients hate hearing that, but I think with Fred would be the best thing. Either agree to relocate somewhere else or give him a license and tell him to go and relocate if you can, or at least make sure that you're skimming some of his profits by way of the license agreement. Okay? That would be my suggestion. With Mary, what would you do with her?
Buy that trade.
Buying it, yeah.
Yeah.
For a decent amount of money.
That's exactly right.
Or as cheap as you can.
That's exactly right. Yeah. A decently cheap amount.
Well, because it would also make a certain amount of sense that she's a sole trader in the sense of she's one person. She probably doesn't have, and if she's come chasing some money, she probably doesn't have, she's got more shallow pockets than Fred and Nigel.
Yeah.
Sorry, Nigel and Roy.
You can normally pick these things up. I mean, even that Golden Circle trademark that we ended up picking up, it was less than 30 grand. I mean, when you think about things like that, as opposed to, the hassle that she can cause with their trademark application, with, the pain and effort involved if she's one of those, lunatics that actually likes to sue for the sake of suing, you're looking at a good, like I said, 150 grand for any proceedings. So you can normally buy this stuff at a cost-effective rate. Hungry Jack's or McDonald's, that's a bit more difficult because they got the money to play with. So you really only got two options here. You either what?
Would one be fold and the other be counterclaim?
Yeah.
You'd probably also want to tell Nigel and Roy, just thinking for the commercial aspect, to probably not get too worked up, and because receiving a letter like that from a giant mega corporation basically would send probably some of the steeliest business operators into a bit of a frenzy.
Yeah, it does. And you would not believe how many successful businesses that they have basically put an end to just by this.
And having read a lot of stuff about McDonald's, they don't like to go. They don't like going to court, even with it's the classic case of the lady who spilled the coffee in her lap.
Yes.
That blew out of proportion like she ended up only getting I think it was only $100,000, $200,000, and the whole case, the history of it, and the sort of legend it became was massive, and it was a hit to their brand.
Yes, that kind of adverse publicity is slightly different. Those kinds of personal injury cases are slightly different to the way that Macca's approaches its IP portfolio. And
would it be more scare tactics that they try and use?
Yes. Normally they will, their general tactic, and I'm just saying this from my experience with them, their general tactic is to jump in at the opposition stage and drag that out as long as they possibly can. Try and hope that you'll run out of money there. And then if you get across the line, they'll either, they may well try for revocation after the thing's been granted, or, they're like the Terminator. They keep just coming back and back. And they really haven't got a whole lot to lose. The problem for trademark owners, I guess, is that you can't sit on your hind legs. If someone is clearly infringing, then you do have to object to the infringing behaviour, because if you just let it slide, that can be seen as a tacit agreement to the conduct. And then if you try and litigate at a later stage, the court will say, hang on a minute, this has been going on for years. Why didn't you talk about this earlier? So they are pretty hot on all of this, and they will sue, and very aggressively so. So, they will jump in early like they did with the McBrat mark. They will try as they can to knock you over in opposition, and then with us they then faded into the woodwork. But query whether that's the case with other people. There's a lot more people that run out of money than than you would think.
Having done a bit of reading, apparently the Jack Daniels IP team is actually quite nice when they serve their cease and desists.
Oh, really?
Yeah, there was one floating around a little while ago that says, they're actually quite cordial in their letter, saying, "Hey, we're glad you're a fan of the brand, but what you're doing is infringement, so you probably should stop."
I think, now that you say that, I think I have seen that somewhere before on an IP forum somewhere. Yeah, look, you can do it with a bit of sense of humour and grace. That's not generally my experience of Macca's. They come down on you like a ton of bricks. Any other queries that we have with this stuff? Does that discussion kind of give you more of a feel for how these things go down and the kinds of games that get played? Didn't really, I'll stop sharing them. I don't think it really came across in the text too much, but I'm hoping that gives you a bit more of an idea of what, the kinds of things that happen. Cool. Any other issues? Everyone's trotting along with their other assignments okay? Sweet. All right then. Thank you guys, and I shall see you next week. Bye.